Welcome to our keynote presentation. Today we'll be talking to two, I think it's fair to say, giants in the field of legal epidemiology, people who have spent long and important careers investigating the health effects of laws and legal practices. Our two guests are Jeff Swanson and Alex Wagenaar. Dr. Wagenaar is Professor Emeritus at the University of Florida College of Medicine and a research professor at the Emory University Rollins School of Public Health. He has received a raft of awards, beginning in 1987 when he received the Exceptional Leadership Award from the American Public Health Association, and most recently when he received the 2016 Nan Tobler Award from the Society for Prevention Research in recognition of his work investigating and advancing the methods and outcomes of prevention research. Jeff Swanson, excuse me, is a professor in psychiatry and behavioral sciences at Duke University School of Medicine and a faculty affiliate of the Wilson Center for Science and Justice and the Center for Firearms Law at the Duke Law School. Like Alex, he has also been recognized frequently for his work. He received the 2020 Isaac Ray Award from the American Psychiatric Association and the American Academy of Psychiatry and Law for his outstanding contributions to the psychiatric aspects of jurisprudence. He received the 2011 Carl Taub Award from the American Public Health Association for his work in mental health services research. For me, both of these gentlemen have been friends and mentors and role models in the work that I've done on legal epidemiology. One of the nice things about getting a large center grant like Temple got for the Robert Wood Johnson Foundation's Public Health Law Research Program was the opportunity to assemble an all-star cast of advisors. And along with Michelle Mello and Jennifer Wood, Alex and Jeff were on the methods core of that research program and helped guide the development of an approach to improving methods in the evaluation of law and its health effects. And that seems like a good place to start this conversation. Gentlemen, we've generally argued that laws and legal practices can be studied like any other social phenomenon, but we often run into a certain amount of skepticism about that claim and about the validity of our methods. I wonder if you could talk to our audience a bit about why we can and should trust the approaches that have been developed in our field to measuring the health effects of law and legal practices. Alex, why don't we start with you?
Well, Scott, thanks a lot for inviting me to this conversation. You know, I've been privileged to work closely with great colleagues across a variety of disciplines, epidemiologists and economists, lawyers and engineers, psychologists and sociologists. And it's all been very rewarding, and especially so working with you and Jeff. Well, on methods, I think maybe a major current problem in the field that we could discuss a little bit regarding methods is the simplistic dichotomization of study designs into RCTs, randomized controlled trials, versus, quote, mere observational studies, with the former leading to causal inference, RCTs, and the latter purportedly not valid for causal inference. This, I think, is a mistake. Randomization is a great design tool to improve causal inference and should be used whenever we can use it. But what's important to realize is there's many other great design elements to improve causal inference. And the creative combination of many design elements can achieve stronger causal inference even than a study using random assignment. What kind of design elements are we talking about? You know, it's the things that we know. Using many repeated measures, perhaps hundreds or thousands of repeated measures in time series studies. It's taking into account the functional form of the effects of a particular law or policy. It's not just the pre-post difference that we're looking at. It's, does the form of how the effect rolls out, does it grow or evolve over time, matching the theory that underlies the law or the intervention, or does it match the implementation, the rollout and the implementation of a new law or policy? And we can use comparison jurisdictions. We can use comparison groups within those comparison jurisdictions. We can use comparison outcomes within the groups that are within the jurisdictions that are passing these laws. That is, we use multiple comparison groups that are relevant, plus we can hierarchically or nest those comparisons to make very strong research designs. And we have things like replications of a policy. People do it across units, across states, across provinces, across organizations, and they do it across time. So we have replications over time. And we can do dose response sort of studies with laws, looking at the intensity, if you will, or maybe implementation fidelity, and see how the effect of the law changes based on that intensity or that implementation fidelity. So, I mean, we have a lot more details on this. You can see our natural experiments chapter in our book on public health law research methods for more. But getting back to the core problem, you know, if we only value RCTs, randomized controlled trials, that directly shapes what we study. And it's often the smaller or less significant question, because that's where the randomization design element can be used. So a sole focus on RCTs leads us to a focus on interventions that have maybe larger effect on an individual person, but it has that effect on a smaller number of individuals, as opposed to our interest in our field. We're looking at laws that are affecting many millions of people, and we're looking for effects across all those millions of people in the population. And the effect on any given single person in that population may be very small, but the aggregate effects on a whole society are very large. So this methodological kind of debate, where some journals and say you cannot even use any language to suggest a causal interpretation unless the study is based on an RCT, it kind of puts a lot of our stuff off the table. And it's not just us as a group of people because we're interested in this topic. It has an impact on science, and it has an impact on society because it shapes what is looked at and what's studied and what's deemed effective and what perhaps is not deemed effective. So randomization is a good tool. You know, we can use it for important questions in our own field, like testing a particular causal link. We have a theory about how a law is working, and there might be a sub piece of that, one mediator, one part of the causal link, about testing out the nature of a particular behavioral incentive or a disincentive or something like that. And even if those test conditions then of that study are artificial, the results can help build the theory. They can lead us to innovate policy, try different things. So that randomization is still helpful, but it only works in those kinds of cases. But if we want to study, which is critically important, the population level effects of law in the real world, it requires more creativity, and it requires us to build in, to create very strong research designs that use multiple elements that enhance causal inference. And that often is done typically without randomization and still creates very high plausible causal inference.
Well, that's a strong case for not letting randomization be a shibboleth in the realm of public health law research. Jeff, does this resonate for you in your work?
Yeah, thank you, Scott, first of all, for inviting me to be a part of this conversation. I really appreciate it, and I so appreciate your leadership in the field of public health law research over the years and the chance to collaborate with you. Alex, that was a marvelous answer. I'm not, and a great takedown of RCT fundamentalism, I think. And I'm not sure I have a whole lot to add to what you said, but let me just go back for a minute to where you started, Scott, which is the skepticism that we sometimes encounter and sort of the pushback and the critique. And I think it's worth thinking about the reasons for that. And I think that there are several, and they're not all misplaced, by the way. There are plenty of examples of bad research in public health law where the design and the method is just no match for the question that the researchers are trying to answer. But I'd also think about the reasons for the skepticism, and I think some of them have to do with the nature of the phenomena that we're studying, the questions we're asking, and what is at stake for society and the answers that we give, and the nature of the audiences for our research. So we're talking to academics across disciplines, we're talking to elected officials and advocates and other stakeholders who are invested in one answer or another to a question. So you ask something like, does this particular state law benefit the public's health, or perhaps does it adversely affect the public's health? What's the social cost, and how do you balance those? The answer is going to be inherently complex because the health benefit you're measuring is almost certainly going to be multi-determined. Is caused by many different things that interact with each other directly or indirectly, and many of those factors that are important are either unobservable or they're unavailable. You might be trying to detect what's a pretty weak effect in terms of a weak signal. You have this problem that the only evidence that's going to be acceptable is something that comes out of a double-blind randomized clinical trial, and which, again, as you said, I completely agree, Alex. I mean, that often gives you an answer with great internal validity that may or may not generalize out to the real world to populations where you have people with co-occurring health conditions living in adverse social environments who may have different attitudes about health behaviors and all kinds of countervailing pressures and so on. When we're looking at the treatment, we're talking about people's exposure to a law. And that's something that's at the individual level, very difficult to randomize, to randomly assign someone to exposure or not exposure to a law. There are ways of doing that at the population level, with these, as you say, repeated measures, difference in different jurisdictions. But it's very hard to do that at the individual level. We have tried. We had to get district court judges to agree to let us flip a coin to assign someone to mandatory versus voluntary mental health treatment coming out of the hospital. And I thought that was going to be a slam dunk. And what happened was, the minute we got into the community with that protocol, that's where the trouble started, because the judges had assigned people to many different lengths of period of mandated treatment, from 2 weeks all the way up to 12 months. And that turned out to matter. And so, once people were out there exposed to the real conditions, we were kind of back where we started, because the people who got 6 months or more of outpatient commitment actually had a great, significant benefit. But our critics said we were just capitalizing on selection, because the people who got renewed and got the long orders were the ones that were doing well. We actually, I think, showed the opposite was true, but that didn't really matter, which brings me to the third, I think, reason why we have a struggle, and that is because the topics that we are studying are controversial. People are often encamped against each other, on the basis of ideological views about regulatory approaches to health behaviors and treatment and so on. And so they're invested in trying to find some reason why what you're studying doesn't work. And we came back and evaluate a legislatively mandated evaluation of New York's outpatient commitment law using a huge database, matched Medicaid records and all these other things. And we did repeated measures kinds of analyses. And, the people that didn't like outpatient commitment still don't, and they still think it's about coercion rather than about access to treatment. So, I agree entirely with your, description. I just think that it is an ongoing struggle, and sometimes arguments about methods are really about other matters, in public health law.